DQ シンポジウムを開催いたします。海外進出される企業様へ、下記の日程にて本年度を開催しております。で、今回は第3回となりますアメリカ大陸における内部通報の最前線といたしまして、カナダの内部通報と法律の観点からの現状、こちらハズローオフィス、そしてブラジルの個人情報保護法令の内容、フェータスレート事務所という2社の事務所での解説をお願いしております。弊社リクエスト社ですが、企業リスクコンサルタント事業を展開しております。内部通報ヘルプラインサービス、不正調査サービス、各種セミナー支援プログラムを提供しております。そして、コーポレートガバナンスに対する3つの D、データ、ディフェンス、デベロップメント、こちらを用いまして、健全で持続可能な企業活動を支援しております。DQ のグローバル事務所とパートナー弁護士のネットワークです。D クエストのヨーロッパを2018年に設立しました。そして昨年度2020年には DQ アメリカを設立しております。本年度計画しているものとしましては DQ シンガポールという形になります。グローバルパートナーとの弁護士ネットワークはですね、アジア、オセアニアをはじめまして、ヨーロッパ、アメリカと主要な地域に拡大しております。実績と安心でご導入優先な社を突破しております。国内から海外のご要望に応じて柔軟な窓口設計を選べるプランです。で、国内は最低ですね、15万円からの導入を可能としております。それではカナダの個人情報保護法令の内容について解説をお願いします。で、こちらはですね、内部通報に関する法令、コーポレートガバナンス、労務管理、そしてデータ保護法、こちらカナダに関するものです。今回のパネリストとしましては、マーティン・アクイリナ弁護士です。マーティンはですね、金融サービスの部門で大企業の主要な社内弁護士として20年以上の実績を持っております。で、またですね、カナダ最大の法律事務所の企業商業グループのパートナーであり、各国、また各事業のサポートをしてきた経験がございます。彼の幅広い専門的経験の中にはですね、ガバナンスに関するアドバイス、調達事項、リスク管理が含まれています。こちらの経験をもとにですね、今回の解説をお願いしたいと思います。それではマーティン・アクイリーナさん、先生、よろしくお願いします。
Good morning. My name is Martin Aquilina. I am an international business lawyer at the firm of Haslow Law Professional Corporation. Our offices are based in Ottawa, the capital of Canada, and we cater to a wide variety of clients and industries located across our country and indeed across the globe. Today, I have been asked by DQuest to give you an overview of the Canadian labor relations in our country with a bit of a comparison with other countries and other topics as well. And about those other topics, I will simply say as an introductory remark that this presentation will be divided into 4 parts. The first part will be addressing labor relations as such, so the relationship between employers and employees. The second part of my presentation will address statutory or legal protections that are given to employees in Canada. The third part of my presentation will be on personal data protection, the protection of personal information in our country. And the fourth and final part of my presentation will deal with whistleblowing and the protections that are accorded to whistleblowers, again, in Canada, with some comparison to the European Union and the United States of America. So to get started, I would simply like to indicate that what I will be saying during this presentation is not legal advice as such. It should not be interpreted as particularized legal advice. It is intended rather to be information of a general character, and I would urge those listening in that they obtain legal counsel before taking an action or omitting to take any actions based on what we'll be discussing today. The other introductory matter that I would like to inform you of before we get into the thick of things is that to understand properly the Canadian framework as it pertains to our 4 topics of today, you need to have somewhat of an understanding of our constitutional regime in Canada. So Canada is a confederation of 10 provinces. There are also 3 territories, which are in the northern part of the country. What that means in practice is that our Constitution, a little bit like the American Constitution and the Swiss Constitution, but with important differences in both cases, divides legislative power between the federal government and the provincial governments, of which, as I said, there are 10. So in many cases, the federal government is empowered to make laws that the provincial governments are not empowered to make, and vice versa. The provinces are entitled to legislate in areas that the federal government is not entitled to address. And in some other cases, both orders of government are entitled to make laws regarding one of the areas we will be discussing today, one or more of the areas we will be discussing today. And then there are constitutional theories to address whether or not one law takes precedent over another, or whether one law is invalid and the other valid. Although we will not get into the details of those because I would then be giving you a course on constitutional law. The other important thing to realize, again, as it pertains to our 4 topics, is that like other countries in the world, our workforce is divided between those employees that are working in the public sector, that work for the government, essentially. And again, because of our constitutional order, we have a federal government, so there is a federal civil service, as well as 10 provincial governments, and hence 10 provincial civil services. So that's the public sector. And of course, we have a private sector. The private sector is probably the one you're more interested in. The private sector are all private or not doing business in Canada. Now, why is it important to have these 2 sets of distinctions, public versus private sector and federal versus provincial sectors? Well, it is simply because, as I indicated earlier, there will be potentially 4 sets of laws for everything we're going to be talking about today. So you might have a law governing labor relations in the private sector in the province of Ontario, another law governing labor relations in the public sector in the province of Ontario, and then laws governing the private sectors in both the province of Ontario and across Canada. So it can get a little complicated in terms of identifying who has the authority to legislate, and as a foreign company, which law applies to my Canadian operations. Is it a federal law? Is it a provincial law? Is it a law governing the public sector or the private sector? Now, usually it's pretty easy to identify whether you're public or private sector, but it may be a little more challenging to identify whether you are governed by a federal law or a provincial law. And I'll be talking a little bit more about that a little later in this presentation. So to begin in earnest with our presentation of today, the first of the 4 topics is on the screen. It is labor relations in Canada. So for the longest time, labor relations in our country, which is a fairly young country, again, not to give you a lesson in history, but we were essentially created in 1867. At the time, the federal government was very powerful. It yielded most of the political power in the country. And the federal government of the day decided that they would adopt a model similar to what was in place in Great Britain. So the laws that were put in place were mostly laws to protect the employer, not so much the employee. So we had a federal statute called the Industrial Disputes Investigation Act. And what happened is in the 1920s, 1925 to be exact, our highest court, which was still at the time a court in England, our highest court was an English court called the Judicial Committee of the Privy Council. They decided in a case that came from the province of Ontario called Toronto Electric Commissioners versus Snyder. There's an extra S there in the presentation. There shouldn't be. It's Snyder. That the government's ability to regulate labor relations for most employers operating in the country, or at least in the province of Ontario, belonged to not to the federal power, but to the provincial power. So much to the dismay of the federal government, who was trying to protect employers, the court ruled that really the employees were to be protected by provincial laws, not by federal laws. So that started the decentralization of our labor law regime, with each province over time progressively adopting its own labor relation laws to deal with the particular industries in their own province. We have a very wide and large country, and the sectors of economy across the country are different and vary from province to province. So that is the principle behind federalism. It allows each province to tailor its policies and its laws to the inhabitants of the particular province. So the federal law was invalidated to a large extent. And what the government did at the time is they rewrote the law such that from then on, the 1920s onwards, it would apply only to two sets of employers, those in specific so-called federal sectors, and those of companies that were incorporated under federal law. To this day, it is still possible to incorporate federal companies. We advise most of our foreign clients who want to do business in Canada to incorporate federally. And it's also possible to incorporate under each province's Business Corporations Act or equivalent. In the days of yore, in 1925 and so on, as I just said, the law was amended to allow the federal government to govern employer-employee relations as long as the company was federally incorporated. That is no longer true. That was also struck down eventually. And today, the statute that has replaced the Industrial Disputes Investigation Act, which is called the Canada Labour Code, only applies to so-called federally regulated employers. It does no longer apply to companies simply because they've chosen to incorporate federally. So who does it apply to? Well, the Canada Labour Code will apply, for instance, to banks, to telecom companies, interprovincial transport, airlines, and a few other categories of private sector employers. So what we have in Canada, and this is not unlike what is found in other countries, is a system of collective bargaining. What that means is that a trade union will obtain certification to represent the employees of a particular employer in a particular work location. And there's a whole process as to how what we call a bargaining unit becomes certified as a trade union to represent a group of employees. My purpose today is not to get into the details of that, but essentially it is a little bit like a political race for leadership. Various groups of people will compete to have the right to represent the employees within a workplace. And eventually those that can garner a sufficient level of support generally 45% of the votes, will go to a labor board and become certified to represent the employees in that group. So it's essentially usually one bargaining agent per employer per workplace, and this changes things in that from that point on, the employer is obligated to negotiate in good faith with the union, and vice versa. The union is obligated to negotiate in good faith on behalf of its members, those that voted for it and those that did not vote for it, but that are ultimately part of that bargaining unit, with the employer. So it changes the balance of power such that you no longer have particular employees dealing with particular representatives of the employer, but rather a group of people that represent and that speak on behalf of all the employees that are negotiating with particular individuals of management that represent the company, the employer. So this is called the Wagner model. It's a model that was adopted based on what the United States had at the time. And I think to this day, it's fair to say that the Canadian labor management model is similar to the American model. So this is what we call the Wagner model. And it's the current framework for collective bargaining. So once there is a collective agreement in place, it is no longer legal for employees to strike or for employers to lock out their employees, which means preventing the employees from showing up at work. So any strikes and lockouts happening at that time would be in effect illegal and would be dealt with, for example, by the courts. So as I said earlier, once a union is in place, management is required to negotiate in good faith with the union, and there is one union or one bargaining agent for each bargaining unit. So an employer across Canada may have to deal with many different bargaining units. Moving on here to the next slide. So it's important to realize, although this does not necessarily affect private sector employees, that certain workers are considered essential services, and they have a limited right or no right to strike. We're referring to people such as ambulance services, hospital workers, firefighters, the police. These employees, typically, if they are in a striking situation, the strike that they will be engaging in will be illegal, and the lawmakers then go to work and pass laws to force them to go back to work because they are deemed essential services. So with the pandemic recently, in certain countries, India, for instance, the United States, there have been calls to declare those sectors as essential sectors. I'm not 100% certain that the fact that they would be essential services from a pandemic, from a COVID-19 legislation perspective, necessarily means that they're essential services from a labor management perspective. So it might be important to keep that in mind when we are talking about essential services. So if you're part of an essential service, essentially the two parties, the employer representatives and the employee representatives, have no choice but to come to the table and agree on what the conditions, the employment conditions are going to be. So this is a little repetitive, but just to drive the point home, so to speak, once a union obtains the bargaining rights on behalf of the employees, it is the one and only legally recognized agent of all of the employees in the bargaining units, which can be seen as a good thing. However, what it means is that the employees themselves lose their individual status of employment. What I mean by that is that they are no longer the owners, if I can say so, of their employment relationship with the employer. Rather, they have conceded that position, if you will, to the bargaining agent, who is the only authority who can then speak on behalf of individual employees. So what that means in practice, for instance, is that the employee loses the right to sue for any breaches of the terms and conditions of his or her employment agreement, or what the employee perceives as breaches of the employment contract. The employee no longer has the right to do that once a collective agreement is in place. And by the way, collective agreement, if you're not familiar with the term, is a very typically long and detailed contract which sets out the rights of the employees, the rights of the employers, and how employers are going to be dealing with grievances, which is the third bullet here on this presentation. So a grievance is a word to indicate the problems that can arise between an employee and an employer. As I said, when there's a bargaining agent, it is no longer a private problem between the individual and the employer. Rather, it becomes a problem between the employee representative and the employer. And that problem cannot be decided by a regular court of law. There is a mandatory process, which is called the grievance and arbitration procedure, where a grievance, in other words, a description of the employee's problem, is put to the employer through the bargaining agent, and the bargaining agent will deal with it with the employer. And if they can't agree, there's a process whereby a private arbitrator, a private court, if you will, is asked to rule on the question. So it essentially creates a private legal system for the employees and the employer that are bound by the collective agreement. And of course, the reason for all of this, as I said, historically, labor management relations were protected by laws that sought to ensure that the employer's property would be protected and that the employer's decision-making power would be protected. Well, of course, over the years, that has shifted towards the protection of employees a lot more so than employers, which is why oftentimes employers would rather, and I think this is not something that's specific to Canada, but employers would rather avoid the presence of a union because once a union is in power, well, the balance of power between the two parties shifts considerably. A union representing hundreds, if not thousands of employees is much more powerful than singular employees when each of these employees tries to deal with an employer, as opposed to one cohesive unit trying to deal with the employer and being in a position to impose terms. At least that's the theory, a lot more forcefully than a single employee could. So the middle ground is what's on the screen here, and it's what's called a joint management employee or board. Now, this is, if you will, a custom solution. It's not something that is mandated by law. It's entirely voluntary for employers to follow this model, compared to, as I said, the true collective bargaining union model, where once a labor board has accredited a union, a bargaining agent, the employer has no choice but to deal with the bargaining agent. This is different. This would be sort of call it mini union, and it's generally implemented in industries that are largely unionized by employers or employees that do not want to adhere to a formal union, that would rather have a simpler, perhaps more flexible system, and not be caught in the politics, if I may say so, that accompany some of the union decisions and indeed the operations of the unions on a day-to-day basis. So the advantage for the employees is that it does allow for some sort of representation other than the representation of a trade union, which would usually allow the employees, if they're not satisfied by what the management employee board is doing, to pursue remedies on their own. They would keep that right. And for the employers, the advantage is the balance of power isn't as drastically altered as when there's a true union in place. So it's much more flexible than a real union situation, and allows then for the theory again being that it allows for a greater liberty in the negotiations between the two parties, employers and employees. Moving now to our second topic. So our first topic was labor relations. The second topic is workers' protection. And the two are obviously tied. Workers' protection in this context is a term that I'm using to speak to employees who are not unionized, who are not represented by a bargaining agent. So typically, the provinces have each their own employment standards legislation, and these govern issues that all employers in the world will be very familiar with, issues such as vacation time, different types of leaves, for sickness, for bereavement, for family affairs, etc., overtime, minimum wage, statutory holidays, notices of termination, how much notice must I give an employee before terminating his or her employment, in what situations may I terminate his or her employment, severance pay, what sort of money must I give an employee when I let him or her go, and so on and so forth. So each province has a law setting out minimum legal requirements in each of these areas. So it's not because an employer is not unionized, or rather that an employer-employee situation isn't subject to a union, that means that the employee is left without protection. To the contrary, there is a protection that did not historically exist, and which was the very reason for the creation of unions in the first place. But now the workers' protections are part of the employer-employee relationship fabric. And so the lack of unions in a particular sector does not mean, far from it, that an employer is free to treat his or her employees or its employees as it wants. It has to comply with a great many sets of rules. And if these rules are not adhered to, well, then the employee has a recourse either before the courts and or before a private a tribunal or a government tribunal. Another aspect of that is, and this is particularly strong in Canada, is human rights legislation. So in Canada, we have legislation that prohibits discrimination and harassment based on a number of grounds. I have them there: age, disability, sex, creed, color, place of origin, ethnic origin, sexual orientation, ancestry, marital status, family status, citizenship, etc. An employee cannot be the victim of an adverse decision based on any one of these factors. So an adverse decision could be a decision not to hire the person, not to promote the person being demoted, etc. it is prohibited for employers to make decisions about their employees that are based on these factors. And the employee has the right to complain to a human rights tribunal. And then the onus is on the employer to prove that its decision was based on other factors than these factors, that the decision, for example, was based on the lack of competence of the employee and not the fact that the employee was a homosexual, or that the employee was not married, or that the employee was too old, that the employee was handicapped. These would have to be shown by the employer not to have been material to the decision of, or even considered in the decision to demote the employee, terminate its employment, etc. So this is important to realize, especially for foreign employers, that this is very, very key in the Canadian context. So this is just an example here. The Canadian Human Rights Act, it prohibits discrimination at the federal level. If you'll recall, I said that there's the federal versus provincial. Well, this is an example of a law that applies to so-called federal employers, and would not be of interest necessarily to private sector employers, although there are other laws that apply to private sector employers. Another example of legislation is the Employment Equity Act. Again, in this case, I'm referring to federal legislation, but this is going beyond even the idea of not discriminating. It's actually legislation that is in place to promote or advance the interests of certain groups which have been traditionally discriminated against, such as women, Aboriginal people, people with disabilities, people with that are part of visible minorities. And this is a law that seeks to give these people within these groups a better chance, if you will, at employment than someone who doesn't belong to these groups, so that we have eventually more women in the workplace, more people with disabilities in the workplace, etc. So this only applies federally. To my knowledge, no province has a law that is the equivalent of this Employment Equity Act. So private employers, by and large, do not have the obligation to promote or to allow greater access to employment for people such as those that are on the slide right here. The other component for which I don't have the slide is occupational health and safety. And this, again, this is not something that's specific to Canada, although we take it quite seriously here. It is law that establishes rules on the health and safety of workers, particularly blue-collar workers, who may have to deal with dangerous products, dangerous workplaces, and in an effort to curtail workplace casualties, there is legislation adopted by virtually every province, which, for example, forces employers to have committees to examine on a regular basis the health and safety situation of the workplace. Again, the idea here is to promote the health and well-being of employees, which at the end of the day is probably good business in any event. Losing employees to illnesses of various sorts certainly doesn't advance productivity. So in the end, I think it is probably a win-win for employees and employers alike to be bound by law that requires that due regard be had for the safety of employees in the workplace. And that leads us to our third topic of the day, which is personal data protection. there would be a lot to be said on such a topic. It could be the subject of hour-long presentations easily. I will only touch upon a few points here. I'm well aware that in Japan, as in many other jurisdictions on the globe, there are laws protecting personal information. Again, not something that's specific to Canada, but from my understanding, the Canadian framework may be a little more restrictive or a little more stern, perhaps, than the Japanese framework, which I understand operates in good part through ministerial or government guidance. I think possibly, without having studied it in great detail, our laws are a little more prescriptive, perhaps, than the Japanese laws. So, with that being said, getting back to what I said at the beginning of my presentation on federal versus provincial competence, for the longest time, we only had one province in Canada that dealt with the protection of personal data, and that was the province of Quebec, who in the early 90s, I remember I was a young lawyer at the time when the legislation came into effect and probably wrote one of the first memos on the topic. Quebec introduced a law to protect information in the private sector. And many years later, the federal government enacted a statute called PIPEDA, and you have what it stands for there in the second bullet of the slide on the screen, which purported to govern the treatment of personal information in all commercial activity across Canada. Unless a province adopts legislation that is deemed to be substantially similar to the federal legislation. And today, two provinces have done that: British Columbia, way at the other end of the country from where I'm at, and Alberta, which is the province next to British Columbia. Both have adopted Personal Information Protection Acts. So by and large, with some exceptions in those provinces, employers there have to comply with the Personal Information Protection Act of each of those provinces. In all other provinces except Quebec, it would be the federal PIPEDA, a statute that would govern the protection of personal information. And when I talk about personal information, what I'm referring to here is the collect, use, holding the information, transferring the information. All those things, all those actions are governed by personal protection data. Again, I think, in 2020, this is not something that's terribly revolutionary. I think we've all heard of GDPR in the EU, and how the EU imposes a more stringent data protection features than, for example, the United States of America. So, I mean, it's very much a hot topic, protecting information that is personal, meaning information that allows someone to identify a particular individual. This is the type of information we're talking about. Much like in Japan, this is the same type of information you would be dealing with under your laws, information that allows me to identify an individual. So if I can't identify the individual through information, it's safe to say that typically will not be subject to these laws. So what may be of more interest to the listeners in this presentation are two things. One is, as I've put on the screen here, the cross-border transfer of information. So for instance, a Japanese subsidiary transferring personal information to the head office in Japan, the question can arise, well, am I allowed to do that? What happens if I didn't specifically get consent to transfer the information? And for the longest time, it was pretty clear that specific consent was not needed until last year, when the federal Office of the Privacy Commissioner, from about April to September of last year, kind of disturbed the situation by suggesting, if not outright stating, that transfers of information, unless they had been specifically consented to, were no longer possible, which caused a number of people to panic, especially subsidiaries of foreign companies, because they never got the consent to transfer information to their head office or to anywhere outside of Canada. The Office of the Privacy Commissioner has since, was almost forced to change its position. People reacted quite strongly to that. And it came back to its original position that transferring information, at least between parties that are linked, so a subsidiary and a head office, was simply the use of information. It wasn't transfer of information per se. And as a consequence of that, no specific consent was required. So that's good news for employers who are transferring information of clients or employees outside of Canada. That is permitted, or at least more permitted than it was for a period of time there last year. Something that's a little newer, and even at that brings us back to November of 2018, is mandatory data breach reporting. Of course, this is a ripple effect from the GDPR in the European Union, where breaches of privacy have to be reported both to the individual affected and to the Office of the Privacy Commissioner in Canada. Here, of course, I am supposing that it's the federal legislation that is applicable, and the breach of the breaches that are targeted here have been quite narrowly defined as the loss of the unauthorized access to or the unauthorized disclosure of personal information resulting from a breach of an organization's security safeguard or from a failure to establish those safeguards. So when this happens, the holder of the information is obligated to report that to the authority as well as to the individuals. I myself in Canada have been, in a few instances, the recipient of such reports, such letters saying that my bank, for instance, was subject to a hacking attempt and that my information may have been compromised, and they are assuring me that they're looking into the situation. So, that is something that's part of our data protection landscape since November 2018. Now, there is a bit of an exception to the reporting of the data breach, and that is the possibility for the holder of the information to engage in what we would call a risk of harm analysis to determine if the breach actually poses a real risk of significant harm to individuals. And if it doesn't, well, there's no need to publicly accuse yourself of it and notify anybody. You just don't need to. So I think here we have a good measure that is meant. Well, first of all, it'll instill more confidence in people in providing their personal information, because they will not be advised of each and every data breach if it doesn't have any significant effect on them. So what is significant harm? Significant harm to an individual whose data has been compromised would be bodily harm, humiliation, damage to reputation or relationships, loss of employment or other opportunities, financial loss, identity theft, negative effect on someone's credit, and damage or loss to their property. So if any of those things are reasonably possible given the breach of data protection, by a third party, then the risk of harm analysis would lead the holder of the data to disclose the breach to both the authorities and the individuals whose data has been compromised, as I stated earlier. So those are the only things the only topics I wanted to touch upon today as it pertains to data protection. As I said, it's nothing revolutionary, at least not in our country and many other jurisdictions. It's been around for some time, and I think everyone understands that a certain level of protection needs to be given to data that's collected from individuals. Maybe just one last note on that. In certain provinces, Ontario being one of them, health data relating to the health of individuals is governed by a whole other legal framework, which is specific to health data and which can be described as somewhat more stringent than what we have here. So those forms of information are governed by other laws that I've not addressed here today. And our fourth and last topic of the day, and possibly one that is of greatest interest to DQuest and its clients, is whistleblower protection. Interestingly, as a preliminary remark, I might say that whistleblowing rather is in our country not a significant topic, not one that's attracted significant efforts by governments, although I need to make the distinction between the private and the public sector. Certainly in the public sector, whistleblower protection is given a lot more thought than in the private sector. And I think the reason for that is simply that in the public sector, employees are deemed to be the custodians, if you will, of the trust of the public, the trust of the electorate. And they have, in that sense, somewhat of a higher duty to the common good, if you will, to preserve the common good than employees in the private sector. So in that sense, employers of the public sector are governed much more stringently when it comes to whistleblowing and the protection of whistleblowers than those in the private sector. Indeed, in the private sector, there is firstly no law obligating anyone to be a whistleblower, first and foremost. Secondly, there is no comprehensive law that governs the protection of whistleblowers, unfortunately, in Canada. I don't doubt that it'll come over time, but for the time being, we're looking more to a patchwork of various laws that may or may not apply in the context of the protection of whistleblowers. One of them is up on the screen here, and it actually comes from our criminal code, no less. And it says that no employers or persons acting on behalf of an employer can take any disciplinary measures or threaten to take such measures in order to compel an employee from abstaining to provide information to a law enforcement authority if that person, that employee, believes that a crime is going to be committed or that a provincial offense, a penal offense is going to be committed. So this is the broadest protection that we have in Canada under any law. It's under the criminal code, which means criminal code being a federal statute, it applies across the country. But unfortunately, well, first of all, it's limited only to employer-employee situations, which is fine. But it's only where the employee would whistleblow to an authority. So it doesn't apply if an employee wishes to whistleblow to the superiors of a particular person or to the board of the company in question. It only applies if you're going to the police or another law enforcement official. It also only applies where you're going to blow the whistle on criminal conduct, a criminal offense, or an unlawful act. And this falls short, if you will, of many conducts or many actions that wouldn't necessarily be criminal in nature, but that could nonetheless be harmful. And by consequence, this is somewhat of a narrow provision. It's really a provision meant to allow people to disclose that a crime has been committed, or that a crime is about to be committed. So it's not as broad. For instance, I've put up on the screen here reference to the Public Servants Disclosure Protection Act, which it only protects employees in the federal government, essentially. And as you can see from the second bullet, in this case, the whistleblower is protected from whistleblowing about anything that's a wrongdoing. So, any conduct that would be an abuse of public assets, of public monies, gross mismanagement, serious non-compliance with a code of conduct, those types of actions. If an employee whistleblows about those types of actions, he or she is protected, can bring these actions forward without fear of reprisal on the part of the employer. So much broader. I think ultimately, ideally, this is the type of legislation that would apply not only to employees and employers of the public sector, but across the board. Then we would have in Canada a comprehensive whistleblowing protection scheme, but we're not there yet. Probably the best whistleblowing program that we have in Canada is that of the Ontario Securities Commission, where we have an office of the whistleblower. It was created in July 2016. It administers a formal whistleblower program. And like what we've seen in the States, it's actually a paid program. So whistleblowers are not only protected from reprisals under the Ontario Securities Act, they are actually compensated for whistleblowing. And I have a press release here up on the screen, which talks about an award that was made of $7.5 million to 3 individuals who provided some timely, high-quality information about company. We don't know about who. Interestingly enough, that stays secret. We don't know about who. Although anybody reading the papers at the time might be able to figure that out. It's not publicly disclosed, but it allows the authorities administrating our Securities Act to take measures against the individual whose conduct is being reported. So the Alberta Securities Commission has a similar program under their Securities Act, although they do not provide monetary awards if disclosure is made, if there's whistleblowing. Now, although this sounds very exciting, the fact of the matter is that the Security Acts of both the Ontario province and the Alberta province, and of any other province, are limited in scope. Whistleblowers are protected to the extent that they're whistleblowing about a company or someone that is governed by the Ontario Securities Act. So, for instance, by and large, any company that is not publicly traded, and that would include the under our rules would include a private subsidiary of a publicly traded foreign company. So someone traded, for instance, on the Tokyo Stock Exchange who has a private company here without offering a legal opinion on it. At first glance, it doesn't seem that this would protect the whistleblower in Canada, because the private entity here in Canada is likely not subject to the Ontario Securities Act. So in that sense, it's a robust program and a robust law, but it only applies to the extent the Securities Act applies, and the Security Act is not likely to apply to anyone who's not in the securities industry or any company that is not publicly traded. Comparing quickly to what we see in the United States. In the United States, I've put there on the screen a number of various pieces of legislation. By and large, without getting into them, you can clearly see that the purview, the scope of protection is much wider, or I should more correctly say that the types of whistleblowers and the types of companies that have to abide by laws protecting employees who whistleblow is much wider in the US than it is in Canada. In Canada, as I said, it's essentially limited to actors under the Securities Acts and to public service employees, both federally and provincially, although I didn't talk about the provincial ones. Likewise, if we compare Canada to the European Union, there's a directive of the European Parliament and Council that will come into effect in 2021. So for those listening in that have operations in the EU, this is something you should put on your radar. And here again, we're going to be seeing in the EU something which is much wider than what we have in Canada, that will set minimum standards for the various member states to adopt through their own laws, laws that will ultimately protect whistleblowers and create a regime that will be applicable to both the public and the private sectors. So this won't be the first time that the European Union leads the way with a comprehensive and precedent-setting legislation. So my friends at DQuest had asked me to whether or not a company that is subject to a whistleblowing regime under its local rules, Japanese rules, for example, how difficult it would be to implement those rules in Canada. Well, the answer is essentially that given the low level of regulation in Canada, it should not be too difficult to implement the regime. It would actually be a voluntary regime in the sense that it wouldn't be mandated by law. So it would be a decision on the part of the employer, a policy, if you will, for the employer not to retaliate against a whistleblower, because we don't have these programs by and large in the private sector. So any company that has a robust whistleblowing program in its own country is likely to be compliant with Canadian laws dealing with whistleblowing, and not likely to have to make many adaptations, if any adaptations, to be able to operate its whistleblowing program in Canada. And on that note, and this is the slide that talks about that. On that note, I would like to thank you, arigato, for listening in, and wish you a great day.
マーティン・アクリーナ先生、ありがとうございました。続きまして、ブラジルの法律と規制という形で、内部通報者、コーポレートガバナンス、個人情報保護、この3つの話題について解説をお願いいたします。で、内部通報に関する法令、コーポレートガバナンス、労務管理、 そしてデータ保護法。こちらはですね、ブラジルの LGPD と EU の GDPR。こちらの比較に関しましても説明をお願いいたします。今回のパネリストはレオポルト・バゴット先生です。レオポルドはですね、独占禁止法、腐敗防止、コンプライアンスの取り組みについての責任を負っております。各産業におけるアドバイスの提供をしております。現在は国際弁護士会の IBA というところですね。腐敗防止委員会の副委員長を務めるなど、レオポルド、サンパウロ支部の弁護士、ブラジル弁護士会倫理裁判所の商工会議所の第20商工会議所第1所の記者も務めているという次第です。それではレオポルド・バゴット先生、よろしくお願いいたします。
今から自己紹介をします。私はバゴット・レオポルドです。はじめまして。ブラジルから来ました。サンパウロで弁護士をしていて、法律大学の講師です。独占禁止法についての修士課程とハーフ防止についての博士号があります。私の妻は京都で生まれましたから、日本語を勉強しなければなりませんでした。勉強しなければ妻と会話ができませんでした。日本語能力試験へのようにも受かりました。今年、日本語能力試験への3を受けます。でも、私の日本語はまだまだです。ですから、今回、プレゼンテーションを英語でします。ごめんなさい。次回は日本語でするつもりです。Well, let me start with the presentation. I have prepared a presentation, some slides to talk about the topic of our presentation, which is laws and regulations of Brazil. We want to talk about whistleblowers, corporate governance, and personal data protection. So here is our agenda. We start talking about laws and regulations related to whistleblowing. Then we move to corporate governance, labor, and management. And lastly, data protection law. We are going to speak about the Brazilian data protection law, which has just come into force, and make brief comparisons with the European GDPR. Probably you had to heard about that in recent years, since it was a very comprehensive legislation. So let me start with law and regulations related to whistleblowing. I know that this is a hot topic in Japan. There have been a few changes in the legislation in the past years. It's not only in Japan, there is a widespread concern in many jurisdictions. There are new regulations passed in Europe, and Brazil is not different. We have seen some changes recently, and we are going to address them today. So the first question you may have is, who is obliged to whistle the blow in Brazil? Do I have an obligation, legal obligation to whistle the blow? Well, basically, if I have a legal obligation, then I must whistle the blow. And if I do not have this legal obligation, I do not need to whistle the blow. But who has this legal obligation? If you look at basically, we are talking about civil servants. If you look at Law 8112, passed in 1990, its Article 111 rules that among the duties of the federal public officials or the civil servants are report to higher authorities any irregularities of which he is aware of in his position, and formally report against any illegality, omission, or abuse of power. And you must bear in mind that not only the federal public official has such obligation, but also all the state public official and local public officials. And public official is anyone who is legally entrusted to a public position, such as police officers, judges, and in Brazil, as the post office is state-owned, even postmen. So you need to be aware who you are dealing with. By contrast, who doesn't have the obligation to whistle the blow? Everyone else, including the employees of the companies. We must bear also in mind that in Brazil, differently from perhaps the United States and the United Kingdom, there is not the the non-self-incrimination privilege. What is it? It means that no one is obliged to produce evidence against oneself. So I'm not forced to produce evidence against me. So it means that also no one is obliged to produce evidence against anyone else, but you may be required to do so if the courts require you. As you can see, whistleblower may not be involved in the crime or the illicit, but when he is involved in the crime, and there are some incentives to whistle the blow. So let's have a look at some of the incentives. What I said is that the general scenario, the previous slide showed how every citizen in Brazil is not obliged to whistle the blow in most occasions. However, there have been changes to create incentives to whistleblowing. Whistleblowing continues to be not mandatory for citizens in general, but the legislation has been trying to create privileges, especially if you are involved with the crime or the illegal activity. For instance, let's start and have a look for the benefits related to competition law. In this case, the benefits apply both to individuals and corporations. And when you talk about lenience program, the way whistleblowing is called in competition law is lenience. Lenience program allows companies and individuals who are involved in cartel or other similar conspiracies to obtain administrative and criminal benefits if they cooperate with the Brazilian antitrust authority. What are the requirements for such a cooperation? First, there are basically 6 requirements. The person must be the first to report the violation. The person must cease immediately the participation in the violation. The person must provide enough evidence to convict the other individuals in companies involved. The company must, or individual must confess the wrongdoing and admit it was wrong. The person must fully and permanently cooperate with the investigation, and the cooperation must lead to the identification of other individuals involved in the violation. There are some benefits resulting from the cooperation in competition law. In the administrative sphere, you may avoid the fines imposed by the Brazilian antitrust authority, or you may even get a 1 to 2/3 reduction of the fines. In the criminal sphere, you may get a reduction in the criminal conviction and prison terms, and even criminal immunity. As you know, in Brazil, there is no criminal liability for corporations, so this is a benefit that applies only to individuals. What about the second area which has received some incentives for whistleblowing is related to anti-corruption. In this case, the legislation is a bit more complex, and the anti-corruption law allows only for cooperation involving corporations. So only if a corporation decides to whistle the blow, it will have some financial benefits. Of course, that this leads to some tension. What will I do with the officers or the employees who were involved with corruption? There are ways to solve it, but it's highly complex. You need to coordinate both the leniency in the administrative sphere before the government and the leniency or the application of plea agreements in the judicial sphere. We are going to talk about it shortly. So basically, the anti-corruption law also created a leniency system which allows for the reduction or exemption of sanctions for companies which cooperate with the investigation of the facts. The criteria are quite similar to the antitrust law. Basically, there are 5 criteria. First, the legal entity must be the first to come forward and demonstrate its willingness to cooperate with the investigation of the wrongful act. Second, the legal entity must cease its involvement with the investigated offense. Third, the company must confess the participation in the wrongdoing. Fourth, the company must permanently and fully cooperate with the investigation. And fifth, the company must rapidly, swiftly obtain information and documents that prove the wrongdoing acts under investigation. So, but what are the benefits for the legal entities that can be obtained by collaborating with the public authorities? Basically, besides the fine reduction, which may range up to 20% of the gross revenues of the company, you may have a decrease in the weight of the naming and shaming sanctions. One of them is the exemption to publish the condemnatory decision by the company in the newspapers. The second is you are not prohibited from receiving funds and benefits from the federal government. Several corporations do benefit from tax exemptions and tax subsidies to perform its operations. So this is something very relevant for many companies. And also, one of the other possibilities is that the company is no longer prohibited to enter into contracts with government. So this is also something very substantial, considering that the government is a major buyer in many areas. Now let me move to the plea bargain in Brazil. This is, you remember that when I was telling you about the leniency in the anti-corruption law, it applies only to individuals. Here, we are talking about a collaboration which applies only to individuals. Sorry, when I said the anti-corruption law, it applies only to corporations. And here, we are talking about the plea bargain in Brazil, which applies only to individuals. And now, here is the strategy used for individuals who are involved with corruption. So at the same time that the company applies for leniency agreement in anti-corruption, under the anti-corruption law, the individual may apply for plea bargaining before the courts. So it's the definition, of course, it's broader and does not apply only to corruption. If you look at the legislation, it says that plea bargaining is limited to illegal acts associated with organized crime, including corruption cases. The main objective is to encourage the accused to provide the criminal system with information about the partners in crime and about the structure and workings of the criminal organization. So the idea is to destroy the criminal organization. Again, there are requirements. They are simpler than the ones in the administrative leniency agreements we saw just some minutes ago. First, the individual must show the willingness to collaborate with the criminal process or investigation. And second, the collaboration must result in the identification of the other authors and participants, prevention of criminal offenses arising from the activities of the criminal organization, disclosure of criminal organization hierarchical structure, location of the victim, or the total or partial recovery of the proceeds of the crime. So there is also another instrument available to whistleblowers who are willing to cooperate, which is a recently created one. It is the Criminal Non-Prosecuting Agreement. It's also applicable to many crimes perpetrated by individuals who are not so serious. So we are talking basically from a criminal perspective to most of crimes that are committed by businessmen during the course of business. This criminal non-prosecuting agreement applies to crimes committed without violence or serious threat to the victim, or to crimes which the bottom jail time is less than 4 years of imprisonment. Again, the requirements are listed in the law, and they must be cumulatively or alternatively admission of guilty, damage compensation, except in the possibility to do so, waiver of assets and rights obtained as a result of the crime, rendering of community services, payment of a fine, and any other condition indicated by the prosecutors, provided it's proportional to the crime. Also, you must be aware that the criminal non-prosecuting agreement cannot be signed if the investigated person is a recidivist. I mean, if the person has already committed the crime, if the benefit has already been given and considered in the past 5 years, and if the fact is a domestic violence related offense. I mean, basically, if the husband uses violence against the woman, his woman, which is a serious concern here in Brazil. Again, having a look at the whistleblower regulation in general, if we're talking about the protection of victims and witnesses, the system is relatively good. It has been established in the late 90s and has been working with relative success. However, if you look at the rules on protection of informants of good faith, they may face a lot of trouble since the legislation is very weak in that area. To change the scenario, last year in 2019, the National Congress passed the new anti-crime measures proposed by the former Minister of Justice, Sergio Moro, in order to strengthen the role of the good faith whistleblower. Among the incentives created, there is a reward of up to 5% over the recovered amount, which may be granted when the authorities are provided with information that leads to the recovery of proceeds of crimes against the government. So basically, we are talking about corruption. As you probably know, there is a similar provision under the capital markets legislation in the United States, and it is clearly, this piece of the legislation is clearly inspired by the American legislation. I think this is the main highlights about the legislation related to whistleblowing. Now, let's see how this relates to corporate governance, labor, and management. I think this is, I would like to highlight that this topic is important when you are a Japanese company, because there are some profound, very deep cultural differences between Brazil and Japan. I think that it comes as no surprise that two countries are very different, and this impacts on the way that the management should behave and advise the laborers. So let's start. I selected 4 main aspects. Let's start with hierarchy. I know that in Japan there is a lot of importance on hierarchy. There is even, the language even shows differences according to your social level and your social position. Here in Brazil, there is not such a difference, and it's the way the C-level management tends to interact with the subordinates, with the employees, is quite informal. It does not mean that it's unkind or there is any kind of lack of respect. No, that's the way things are, and people behave in a very egalitarian way. I mean, the business, the leadership of the company does not feel offended if the employee calls him or her in an informal way. The second difference regards seniority. Again, Japan, based on what I know, puts a lot of respect on elders, who are treated with deference, respect. In Brazil, younger people tend to treat older people almost as if they were of their age. So again, there is not such a difference, and there is no need of too much deference or too much respect in the way of speaking. Moral harassment, again, it used to be common in Brazil, and but nowadays, moral harassment, offending subordinates, is no longer acceptable, and employees, they must be asked to do their work, but you should be very careful about how you deal with targets, and how you explain to an employee that he's not performing well, and for this reason he must work a bit hard. You must be very careful about that. Otherwise, the employee may feel offended and start to look for his or her rights. Of course, sexual harassment is also unacceptable in Brazil, culturally speaking. And there is a final piece of information that is very relevant in regards to loyalty to the corporation, to the employer. Loyalty is not such a strong trait in relation to corporations. Employees do not start a job hoping to work the entire life in that company. It may happen, it happens, and people normally are happy when it happens. However, the vast majority of jobs here in Brazil, they have a relatively high turnover. And this is one of the reasons why employees are not afraid of suing the former employee. It means that every time you are going to fire an employee, and you probably need to fire an employee, and the employee goes to court and files a complaint about something that happened, something that he did not receive, if he worked too much and was not paid. So there is a real industry of litigation, labor litigation in Brazil. And you must be careful because there are ways to mitigate this risk. Still in relation to corporate management, I think that the legislation in Brazil regulates in details how the management of publicly traded companies should behave. Even though this is not applicable to closely held companies or subsidiaries of foreign companies, the standards have been used by courts. So it's good to have an idea which are the duties of the management. According to the corporation law, Article 153 rules that the corporation officer should employ the care and diligence which an industrious and honest man would normally employ in the administration of his own affairs. In other words, the corporation officer should manage the company as if it were his own company. Of course, this is a very generic way of saying, and for this reason, the Brazilian Securities and Exchange Commission defined, detailed this duty, which can be split into 5 duties which are to be complied with. First, the duty to stay informed. The manager, the officer, should know what he's doing about. He should not take a decision without knowing the matter. If he does not know, he should go and get information about the matter. He should investigate, he should talk or hire experts who would give him a better view of the matter. The second duty is the duty of vigilance, or the duty of care, the duty of pay attention. It's the duty that means that the officer must monitor the progress of the business and operation of its decisions. So if the company decided to increase the price, it must confirm that the price was increased. If the company decided to shut down a branch, it should follow up and see if it was shut down. So this is what the duty of vigilance means. Duty to investigate. Whenever there is a suspicion of wrongdoing, the manager, the officer, should necessarily investigate the fact. He cannot just turn a blind eye on that. Duty to intervene. If the officer learns about any kind of wrongdoing or irregularity or wrong business practice, he must intervene and prevent the situation from happening and remediate the situation. Finally, the duty of attendance. He must go to the meetings of the department, of the corporation, and it must justify whenever he cannot go. This is something these criteria have been used to determine whether the corporation officer has been compliant with its duties. Now that we are talking about compliance, let's go a bit deeper and have a look at which are the expectations from the C-level management when it comes to compliance. Compliance, as you know, has become a worldwide fever in the past years, and in Brazil, it has become very important. individuals are no longer, in the past there was the government and the prosecutors were very ineffective and could not prosecute business crimes. But in the past years, there was a real change and several corruption and cartel cases were found guilty. For this reason, it's important for the company to behave and to make evidence that it is compliant. As you may have heard, everything related to compliance is about document. You must document everything to have a defense whenever anything wrong happens. So basically, there are 4 duties or expectations of a good compliance program or behavior of a businessman in relation to compliance. First, there must be independence of the compliance department in relation to other areas. Of course, that some companies are small in size and they do not need to have an independent compliance department. This applies only when the corporation is large enough to have a compliance department. The C-level must set the example for the employees, the so-called tone at the top. We are going to examine this topic in detail a bit ahead. Finally, never ignore signs or warnings regarding possible irregularities. And also, do not wait something to happen to act. If you know that there is something wrong, you should take advantage of your knowledge and act before the worst happens. And it has become clear that I did not know, it's no longer an excuse or defense. The company should actively learn and get information to make the decisions. So I did not know that the third party was a corrupt corporation and I did business with that. But did you check whether there was any wrong or negative piece of information in the press? If you did not, if you have not taken the necessary steps for a third-party due diligence, you are in a bad situation. Key approaches to ensuring compliance. Basically, it involves 3 steps: commitment, integrity, and responsibility, which can be detailed into 4 criteria. Demonstrate ethical leadership, communicate expectations. The C management must also exhibit ethical decision-making and improve the employee speaking up. Let's have a deeper look at ethical leadership. Employees know honest people when they see them. And this is why the example of the leadership is very important. You establish an ethical culture when you act with a commitment to honesty and integrity. There are situations when bribes are asked, and so how do you do? How do you behave? According to the compliance best practices and what's expected in Brazilian legislation, the employee and the C management should say no right after the bribes are asked. This is not the way our company works. This is not our policy. I know that culturally speaking, it's very hard for a Japanese to say no, but it is something important to do in Brazil. When something asks you to do something wrong, you must demonstrate the commitment to doing the right thing. And that commitment must be displayed immediately after. Oh, I need to check with my superior, my boss. This kind of attitude shows that there is not a strong ethical commitment in the corporation from the perspective of Brazilian law. Your actions as a manager or officer must be transparent, publicized to the extent it's possible, and communicated through all channels. So let's move to the next slide. You can see that there are several steps which limit or show how the ethical leadership can evolve from a completely clear and honest approach to violating the law. There are several ways. For instance, you may not be clear enough and lead to misunderstandings about the message. If you're not communicating clearly, no, you should not, for instance, pay bribes or send mixed messages. When you sometimes make a joke about someone who was fool about getting caught by the police, or when you turn a blind eye on something that's being wrong in the company, or when you tolerate wrongdoing. Some employee has, for instance, bribed a police officer because of fine tick, because it was speeding, and you don't do anything about that. So there are several ways in a problematic environment to destroy the ethical leadership. You must be careful to avoid this kind of scenario. And how do you avoid that? You must communicate your expectations as clearly as possible. You must talk about ethics in one-on-one discussions. You must talk about ethics during staff meetings. You must ask how tasks are being accomplished to your employees. You must praise good actions and behaviors. You must criticize or eventually punish employees who have breached the policies of the company. And again, the tone at the top shows the example for the entire corporation if you're in the leadership. Again, as part of the compliance program, you must have an effective whistleblowing channel. And sometimes the companies are surprised that nobody uses the whistleblowing channel. There may be a good explanation and there may be a bad explanation. The good explanation is when everyone trusts the ethical leadership and contacts the superior and reports any kind of wrongdoing or uneasiness with the work environment to the manager, to the director, and they do not go, for instance, to the hotline, or do not talk to the human resources or the ethic and compliance department. They go straight to the person who should be taking the lead. This is the best scenario. However, sometimes this does not happen because the leadership is not reliable from the perspective of the employees. For this reason, the corporation must, from a good governance perspective, have in place all the instruments which will allow the internal controls to operate. And here we have internal audit, legal department, business ethics and compliance, human resources, integrity hotline if you're available. And of course, the company, after creating all these mechanisms, it must, according to the best practice, prohibit retaliation and in all levels. Retaliation, non-retaliation is not a requirement of law, but several companies have been using it and adding it to the ethics code of the corporation. Of course, you do not need to add the non-retaliation clause to your code of ethics, but it's advisable. If you add it to the code of ethics and compliance program, you must be aware that courts will pay attention to that and will use it against you if you are not guaranteeing the non-retaliation to your employee. So courts, even though it's not regulated, have been using the non-retaliation clause quite often. Now, let me go to the next topic, the data protection law. As I mentioned at the beginning of the presentation, there is a new data protection in force in Brazil since a few days ago, and since September 17, 2020, and it is largely inspired in the European GDPR. You probably, as Japanese companies operating globally, you probably have to make some changes in your policies and proceedings due to the GDPR. Brazilian legislation, it's dubbed as LGPD. It has also, it bears many similarities with the European GDPR. The first concern of a Japanese protection is, does this new Brazilian data protection law apply to me? Well, the question is, if you have business with Brazil anyhow, the trend is that it applies to you. It applies to business and organizations which process or control personal data, people in Brazil, regardless of where those businesses and organizations are based. So let's imagine a business based in Japan, but with Brazilian consumers via website. Of course, the consumers to buy products must provide the information, their name, their addresses, their credit card numbers. So this kind of business will be under the reach of the Brazilian data protection law. If you register Brazilians on foreign databases for using in product sales in your country, and if the personal data has been collected in Brazil or in any other processing operation that takes place in Brazil, for instance, in supermarkets, retail chains, etc. A common concern about the data protection law regards the international data transfer. Here, we moved from a scenario when everything was allowed to a scenario when, in principle, data transfers from one country to another are not allowed. However, there are exceptions, and you may try to use them to make international data transfers. There are several possibilities of data transfer which are listed in this slide. For instance, if they are authorized by the National Data Protection Authority, in the event of a commitment under an international agreement, when necessary for the execution of public policy, when the holder has given the specific consent, when necessary to comply with regulatory or legal obligations, transfer to ensure adequate protection of individuals, proof that the controller have certain guarantees that have been met, like contractual clauses, global standards, certificates, transfer between public intelligence and investigation agencies, and whenever necessary for the protection of the holder's life. When can I process the data? Again, here in Brazil, we moved from a scenario where there was no restriction to a very regulated scenario. You can only process the data when it's authorized by law. In this regard, Brazilian legislation is more flexible than the GDPR, the European GDPR. The GDPR consists of 6 authorizations, while the Brazilian legislation has 10 authorizations. Look at the situations in Europe, they are quite similar to the ones in Brazil. Of course, consent is a common ground. You must have a specific consent to process any data. To comply with legal or regulatory obligation by the controlling shareholder, to comply with obligations before the public administration. You have also authorization to process the data, to conduct studies by research body, when it's necessary to guarantee the performance of a contract, for the exercise of rights in judicial, administrative, or arbitral proceedings, for the protection of life or physical integrity, just like international transfer, for the protection of health, when necessary to meet the legitimate interests of controller of third party. Legitimate interest is a very wide concept, and it applies, for instance, when the company needs to investigate an individual and must take the computer and web phone and the telephone from the individual, and for credit protection purposes. So you see that the situation in Brazil is more flexible than Europe, although it's stricter than we used to have until the new law came into force. When it comes to penalties and sanctions, Brazil also moved from a system when there was no fines or sanctions to data protection violations to a system in which there is substantial fines for data breaches. The penalties they are not so serious as in Europe, but they are also still considerable. The fines may range to 2% of the group revenues in Brazil, limited to 50 million reais. Roughly speaking, this is about 20% of the value of the European fines. Daily fines of the same value. Publication of the infringement in the internet or newspaper. Blocking of personal data involved, or it means that you can no longer process the data. Eliminate the data, personal data involved. Partial suspension of the operation of the entire database. Suspension of the data processing activity, and even partial or total ban of the data processing activities. So it's somehow similar to Europe, but the sanctions are slightly lower. Of course, that here, just like in Europe, we are talking, the main concern is about the reputational impact that data breaches may have. If you allow me to elaborate on that, Europeans and Japanese are much more aware of the risks of data breaches. They care much more about their privacy. In Brazil, there is not such a culture. I mean, it's not so strong compared to Japan or Europe, which means that it will take some time for people to realize that this is a serious matter which should be taken and reviewed with care. In relation to the data protection officer, this is also something new that was brought by the new legislation. The data protection officer is a person designated by the company, which is responsible as a kind of communication channel between the controller, the data subjects, and the National Data Protection Authority. There are no formal requirements to be a data protection officer. He may be any person in the company. It may be an officer, a manager. It may be someone who has expertise in IT, or maybe a person with legal education. So it may even be a third party outsourced from the company. The identity and contact information of the data officer shall be publicly disclosed in clear and objective manner, preferably on the controller's website. So it's mandatory to disclose who the data protection officer is. And the data protection officer has several activities like accepting complaints and communications from data subjects, receiving communication from the national authority, guiding employees regarding contracts, and carrying out duties as determined by the data controller. So last slide, let me go to data security and breaches. This is something that shows the importance of cyber security. And here, the legislation is quite similar to the European. It's world standard. What I have to say is that the legislation in Brazil is very sensitive to the size of the companies, the size and sophistication of the companies, which are subject to the law. You do not need to have a very sophisticated compliance and cybersecurity program if your company is small or medium-sized. You must have what's adequate and considered to be best practice or market standard in Brazil. You have to bear in mind that you don't need to go for the best firewall or the strictest security measures if your business doesn't require it. If you are, for instance, an industrial company which does not handle any sensitive data, you don't need to have very sophisticated data protection systems. By contrast, if you are selling products through the internet, or if you are storing personal data, then your situation is different and you should pay more attention to that. So the level of cybersecurity should be adapted to the size of the corporation and the kind of business they are performing. Domo arigatou gozaimashita. This is what I have to say about the 3 topics. I hope you enjoy it. And whenever you need additional information, I'm available to do so. Domo arigatou gozaimashita.
レオポルト・パゴット先生、ありがとうございました。本シンポジウムでは、次回は第4回としまして、アジアにおける内部通報の最前線というものを企画しております。一方ですね、GDPR の施行をですね、各国に対する法律を制定しなければいけないという規制も始まっております。でこちらにつきましては、第4回を入れ替わる形になるかもしれませんが、ドイツのフランク弁護士という方にお願いすることになります。それではご清聴ありがとうございました。